Hey, what's going on, everybody? Welcome back to Man Views, where I cover videos that can possibly help our fathers and men. I'm B, the CEO, and let's get to it.
All right, one moment, please, and I'll get the record started. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Tuesday, April 9, 2024 at 8:31 a.m. And this is for case 2015-1447 DS, Alexis Tabaka versus Christopher Tabaka. Attorney Elaine for defendant.
Good morning to all of you.
Good morning.
Morning.
I wanted to just clarify on the record, I did get, our office did, I didn't, but our office did get a call from Miss Elaine last week in which she informed us that she was withdrawing the motion to show cause for failure to pay attorney fees as they had been paid. She also informed us, Ms. Tabaka, that you were withdrawing your motion for attorney fees. Is that correct?
Yes, Your Honor.
Okay, thank you. So we are basically proceeding on the two motions to show cause in this matter. One filed by defendant, one filed by plaintiff. And maybe you could, I guess, tell me, I'm not certain now, I didn't have the dates as to which motion was filed first.
Ours was filed first, Your Honor.
I thought it was, you filed yours back in when, October, November?
October,
Okay.
Your Honor.
Okay. So we'll make you, Ms. Elaine, the moving party, at least in regard to that. So is there any preliminary matters before we commence, Ms. Elaine?
I don't believe so, Your Honor.
Okay. Ms. Tabaka?
No, sir.
Okay. Ms. Elaine, do you want me just to make an opening statement or proceed to your proofs?
I do, just a brief opening.
Okay.
Yeah, this court is familiar with the issues surrounding what I have called, through the history of the proceedings, the work parenting time provision of the parties' 2015 custody order. As a brief reminder, the parties designated parenting time so that if Alexis was working, Chris would be afforded that parenting time. And as this court will, I'm sure, recall from our first show cause hearing on this particular issue, everything had gone fine with that work parenting time provision until Alexis got angry with Chris in the summer of 2021 because he filed an ex parte order regarding contact with her boyfriend, which resulted in a no contact. And from that day forward, Alexis has done everything in her power to ensure that Chris does not get the children when she works, including violating the order repeatedly, and now to the extent of becoming voluntarily unemployed for a significant number of months so that she could not, so that she wasn't working, so that she would not have to give the children to Chris. It's really outrageous. It's a sad situation because she's punishing these children and keeping them away from their father for her own petty vengeance. Now, this court held a show cause hearing on the violations that we alleged, and an order entered on September 15th, 2023, and awarded Chris 39 and a half hours of makeup parenting time. The court also ordered that Alexis pay half the attorney fees for that proceeding, which she has now done. The subject of the last show cause hearing were violations of that work parenting time provision up through November 9th of 2022. And today's show cause involves her violations from that date up through June 23rd, 2023. And the reason for the gaps, I guess, is because by the time we got to the show cause hearing, there had been more violations. And then this hearing will encompass those that had occurred up until that hearing, and then those following that hearing up until June 23rd, 2023, which was essentially the end of her work with the Calhoun County Sheriff's Office. Notably, Your Honor, we deposed Alexis on August 12th, 2023. And at her deposition, I presented her with her timesheets, and I presented her with our spreadsheet, which is our exhibit A or B, A, I think today. That spreadsheet, what we claimed were the violations of the work parenting time provision, the dates and the times of those violations. And we went through every single date on that spreadsheet with Alexis at that deposition. And in short, and we have her deposition here today, she testified that the work hours listed on her timesheet were correct. So she validated all of those. And she testified that if the times we had identified on our spreadsheet were indeed her parenting time, then yes, she had violated the work parenting time provision by not allowing Chris to have the children. And we, after that deposition, Your Honor, tried to avoid this hearing. We tried to avoid taking up this court's time, and I'm saying this because I think it goes to the claim for attorney fees that we will make today. After the deposition, we sent a demand letter to Alexis's prior counsel, demanding, essentially saying she admitted these violations, and this forms the foundation of our claim. And so we demand this make-up parenting time. We provided the timesheets, we provided the deposition references, etc. And we were denied that resolution and were forced to take this matter to court. So all in all, Your Honor, there are a couple errors in the timesheet that I'll go through just through the testimony, but at the end of the day, there are 53.5 hours of make-up parenting time that Mr. Tabaka is entitled to. And we would like this court to order that parenting time be made up to him in the following ways. He would like to select 3 to 10 hour blocks of parenting time. Just like the last time, he would provide 7 days notice of the dates that he wants this make-up parenting time to occur. And he would agree, just like last time, that he would not be able to choose and supersede any of Alexis's set holidays. We would also ask, Your Honor, just like last time, that attorney fees for this proceeding be awarded, which would include some of the deposition time, not all of it, but some of it spent on this piece, the efforts to settle, the show cause motion itself, this hearing, and a couple false start hearings that we've had up to this date. Thank you.
Okay, thank you. Mr. Baca, do you wish to make an opening statement, or you can reserve your opening statement, or you can waive your opening statement?
I'm not entirely sure how it works, Your Honor, but I'll make an opening statement.
Okay.
Just in regard to most of what Ms. Elaine has just said is not true, and it is meant to mislead this court. And I have all of the evidence that we'll be going over today, including much of what Ms. Elaine talked about. And in the deposition that she is referring to, I did not make those admissions that she's claiming to the court, but that can be read from the transcript. I certainly have not violated your order that you put in place on May 12th, and I think that you will find, Your Honor, that almost everything in their claim actually goes entirely against your rulings for that date, which I will go over with exhibits. And I also have several witnesses to testify on behalf of me regarding a lot of the false things that Attorney Elaine just presented to this court. So I don't enjoy this, but I'm ready and I'm prepared to provide the evidence to show that those are untrue claims, that this is a frivolous case being brought upon me just to harass me. I guess that's my opening statement, Your Honor. I apologize. It's not glamorous.
That's fine. Ms. Elaine, you can call your first witness.
Yes, Your Honor, I would ask that the court sequester any witnesses now that Ms. Tabaka has said that she has some. I don't know where they're located and they may not be with her, but just in case they are.
Okay. Ms. Tabaka, any response to the sequestration request?
No, sir. Everybody should be attending in over Zoom. There's just one person, and my mother is in my home, and I will let her know that there's a request for her to be sequestered. So give me just one moment so she knows to not be shot.
Okay, thank you.
All said. Thank you, Your Honor.
Okay, thank you. Court will grant the request for sequestration. The court will inform any of the witnesses that may be viewing this through Zoom or in any other manner that they are not to do so and are prohibited from doing so until such time as they have completed their testimony. And if I will state, in the event that a person does view these proceedings and we find out about that later, we could strike their testimony or they could be held in contempt of court. So with that, Ms. Elaine, you can call your first witness.
Thank you. I call Alexis Tabaka.
Okay. Ms. Tabaka, we'll have you raise your right hand and be sworn in.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Thank you.
Go ahead.
Jesus, will you enable me to share my screen, please?
Yes, one moment. You should be able to do it now.
Thank you. Good morning, Ms. Tabaka.
Good morning.
Good morning. I'm going to show you what we have pre-marked as Defendant's Exhibit B. Just give me 1 second to get it up on my screen here. Adjusting that size. All right, are you able to see that?
Yes.
All right, and could you identify this document? And for the record, it's 25 pages long. It starts with a business record certification, and then the second sheet is entitled Calhoun County Hourly Employee Timesheet 2022. Do you recognize this?
I recognize it to be, it's a time card from work.
All right, Ms. Tabaka, these time cards were ones that you signed and submitted in the course of your employment with the Calhoun County Sheriff's Office, correct?
Correct.
And you signed them as true and correct?
Correct.
And you stand by that certification today?
Yes.
All right, so I'm just going to start with Wednesday, 11/9, and these would be from 2022. Worked 8:30 to 12:30 p.m., correct?
Correct.
And that was your parenting time day that day, correct?
Correct.
And you did not allow Chris to have the children while you worked, is that accurate?
I only worked a half a day.
I understand that, but at no time during that day did you allow Chris to have the children?
He did not have the children that day, if that's
Okay.
what you're asking.
It is. And on 11/15, which was a Tuesday, you worked from 8 to 4?
Correct.
And that was your parenting time day?
Correct.
And Chris did not have the children that day, correct?
Not to my knowledge, no.
Blow this one up, skipping that one. On 11/18, which was a Friday, you worked from 9 to 12:30 p.m.
Correct.
And do you recall that this was a snow day?
I do recall that it was a snow day and that Chris did not request to see the children or receive the children that day.
And you did not tell him that you were working, correct?
That I do not recall.
Okay. 11/23, you worked from 8 to noon and 1 p.m. to 4 p.m., correct?
Correct.
And that was your parenting time day?
It was.
And Chris did not have the children on that day?
Not that I'm aware of.
11/29, you worked from 9 to 5?
Correct.
And that was your parenting time day?
Correct.
And Chris did not have the children on that day? Correct?
Well,
From any time between 9 and 5, he did not have the children?
he did spend time with the children between those hours. And I apologize for not making this a yes or no answer, but that pertains to the other date, which was also piano day. Chris would always be with Maddie from the time she left school at 2:30 until the time she ended her piano lesson at 3:30. So he was actually spending time with the children on that date. I didn't stop him. But that is part of that time. Yes, he did spend time with the children on those days.
Not by arrangement with you because you were working, correct?
Can you ask your question again?
Sure. To the extent you allege he spent or saw the children after school that day, that was not by any arrangement between you and him. Hang on.
No, he's at the school every single day on my parenting days. So,
and you don't approve of that, correct?
I don't think that it is.
Yes or no, ma'am? You don't approve of that?
I don't approve of having to see my ex on my parenting days.
Right.
It's not necessary.
You don't approve of him coming to the school outside of his own parenting time. So if he was at the school that day, that was not by agreement with you pursuant to the work parenting time provision. Is that accurate?
Ask your question again. I'm sorry.
Yes. If he was at school that day on 11/29, that was not part of an agreement with you pursuant to the work parenting time provision.
Thought that was his own free will.
Okay, so your answer is no, it was not by agreement with you pursuant to the work parenting time provision.
That's kind of a long answer, and it's too much for me to. He was there on his own free will.
All right. And on 12/2, Friday, was that your parenting time?
What was the date again?
12/2, Your Honor.
12/2, okay.
Was
Yes.
that your parenting time? And you worked from 9 to 4 that day?
I did.
And Chris did not have the children that day, correct?
Correct.
And on 11/7, was that your parenting? I'm sorry, December 7th, 12/7/2022, was that your parenting time?
Yes.
And did Chris have the children that day while you worked?
Not that I'm aware of.
And you worked from 9 to 5?
Correct.
And on 12/13, you worked from 9 to 5?
Correct.
That was a Tuesday.
Correct. It was a piano day.
And Chris did not have the children that day pursuant to the work parenting time provision, correct?
Other than his exercising parenting time of his own free will.
And on 12/16, was that your parenting time day?
Yes,
And you worked from 9 to 3:30?
I did.
And Chris did not have the children that day, correct?
Unless again, he was exercising parenting time of his own free will, and Maddie was at school till 5 p.m. that day for a dance.
And did you let him know that you were working until 3:30?
I don't know.
On 12/22, that was your parenting time day?
12/22.
My apologies, 12/21.
Yes, it was.
And you worked from 8 to 5 that day?
Correct.
And did Chris have the children that day pursuant to the work parenting time provision?
Chris had the children that day on his own free will. The children had math Olympiad and piano after school.
Okay, did you make arrangements with Chris to have the children pursuant to the work parenting time provision?
I do not believe that the judge put that in order until May 12th. You keep referencing that, but that was something that the judge required me to do in his ruling from May 12th forward.
So all I want to know is the answer to the question, and then you can make certainly whatever arguments you want to make during your case. But my question to you was, did you arrange for Chris at all via either his request or your information to him that you would be working, that he would have the children on 12/21 pursuant to the work parenting time provision?
Not that I'm aware of.
Same questions for 1/10. Was that your parenting time, January 10th?
Yes.
And you worked from 10 a.m. to 6 p.m.?
Yes.
And Chris did not have the children pursuant to the work parenting time provision on that day at either, correct?
Correct, other than his own free will.
Well, hold on a second, just to clarify, because I need to, Ms. Tabaka, when you said he had the kids on his own free will, just so I know, on what dates that you've talked that he had the kids. So don't say he's had the kids on his own free will. If he had them, I want to know whether he had them or didn't have them.
Yes, sir. And I'll go back over that again when we go over this, but every piano day, which are most of the days on this list, Chris would, even though it was my parenting day, show up to the school when Maddie gets out at 2:30, and he would remain with Maddie from 2:30 to 3 when her piano starts, and then also remain at the piano lesson from 3 to 3:30. So for an hour's time, he would be with her on those days that they're claiming.
And Your Honor, I would object to that testimony based on foundation.
Well, I'll take the answer because I asked the question. I think it's relevant.
All right. And Ms. Tabaka, what is your foundation? Do you know what I mean by foundation?
Not necessarily, but I have witnesses that
Okay.
will attest to his presence, if that's what you mean.
Okay, it is what I mean. How is it that you are able to testify to that from your own personal knowledge? Do you have personal knowledge, meaning you observed Mr. Tabaka? Do you have that sort of personal knowledge that you observed Mr. Tabaka with the children?
I have witness that has observed.
Okay, I'm asking you a specific question. Do you yourself did you observe him on the dates in question?
No, not with my eyes.
Okay, did he tell you on the dates in question that he had been with the children?
He never informs me when he is with the children on my parenting days.
So the answer is no, he did not tell you that, correct?
No, ma'am.
Okay. So 110, I think we covered, right? You worked from 10 to 6. And it was your parenting time day, right?
Mhm. Yep.
All right. 123, you worked from, and Your Honor, this one is not on the spreadsheet, and it's one of the corrections we had to make today. There's 2 corrections, that's one of them. 123 of 23, ma'am, you worked from 9 to 5, correct?
Your Honor, may I make a statement real quick?
No, you can answer the question. You can make a statement later.
Yes, sir. 123.
That would have been Monday, Miss Tabaka, a Monday.
Mondays, Attorney Elaine, are never my parenting days. They're always Chris's. So I'm not sure what you're getting at there.
Well, that's what I wanted to know, if that was your parenting time day. So you say that 123 was not your parenting time day?
No, Mondays are never my parenting days.
And what is Chris's parenting time on Mondays?
If it's a school day, he gets them when they get out of school.
Okay. And 127, was that a parenting time day of yours? That was a Friday.
Yes,
And you worked from 9 to 3:30?
correct.
And to the best of your knowledge, Chris did not have the children pursuant to the work parenting time provision that day, yes?
Correct. There would have been no time in there.
2-1, February 1st, which was a Wednesday, did you work from 9 to 4:30 p.m.?
Yes,
And Chris did not have the children that day, and it was your parenting time day?
other than the time he spent of his own free will.
All right, I'm gonna ask you not to testify to that anymore because you don't have that personal knowledge, and you are free to bring on your witnesses. But if you don't have that personal knowledge, you can't testify to that. Does that make sense?
Sure.
All right. So he did not have the children on 2-3 pursuant to the work parenting time provision, correct?
Sure.
And on 2-15, that was a Wednesday, you worked from 11 a.m. to 4:30 p.m.
Correct.
And that was your parenting time day?
Yes,
And Chris did not have the children pursuant to the work parenting time provision, correct?
that's my knowledge.
Same with 2-21, was that your parenting time day?
Yes,
You worked from 10:30 a.m. to 4:30 p.m.
correct?
And Chris did not have the children that day either pursuant to the provision at issue.
And that's my knowledge.
Same with 224. You worked 6:30 a.m. I think that says to noon.
Right.
And Chris did not have the children at any time during your parenting time.
Nope, that was another snow day.
All
That-
right. So
yeah.
the children were not with you because you were working during the snow day, and then they were not with their father, correct?
Well, the children were already with me because it was a Friday and school was canceled because of the bad roads, and he did not request to have the children or come to get the children to travel on the roads to get them.
Did you let him know you were working?
I do not recall.
All right. 3-1. The only way that the two of you communicate at present is our family wizard, correct?
Correct.
And so if there had been communication about that day, we would find it in our family wizard. For instance, if you said, hey, I have to work.
Correct. But of
Alright.
course, as I
Okay.
mentioned before, the judge did not
Thank you.
rule that until May 12th.
Yep. March 1st, you worked as well, and that was a parenting day of yours, correct?
Correct.
And Chris did not have the children pursuant to the provision.
To my knowledge,
Same with 3/15, you worked from 9 to 4:30,
correct.
your parenting time.
Pardon?
That was your parenting time,
Yeah, that was my parenting day.
and Chris did not have the children.
Not to my knowledge.
3/21, you worked from 10:30 a.m. to 5.
Yes,
That was your parenting time day.
it was.
Ms.
Chris did
Elaine,
not
what
have-
was the date of that again?
That one was 3/15, Your Honor. 3/20, sorry, we did 3/15 and 3/21 on this page. I think that was
21, okay,
3/21.
thank you.
Yeah. All right, and Chris did not have the children, Ms. Tabaka?
Not to my knowledge.
That one we had marked, but then we ascertained that was a night work, 10:30 p.m. So we're gonna skip. We're not asking anything from 3/31. 4/10. You had the children, or you say Monday was his parenting time?
Correct. Mondays are his parenting days.
Okay, yeah, so on our chart, we don't have that one. 4/12, that was your parenting time day, correct?
Correct.
And you worked from 9 to 4:30?
Correct.
And Chris did not have the children that day pursuant to the provision?
Well, I don't believe so.
4/18, same question, your parenting time?
Correct.
You worked from 9 to 5?
Correct.
And Chris did not have the children.
To my knowledge.
4/21, was that your parenting time? It was a Friday,
Yes,
and you worked from 9 to 4,
correct.
and Chris did not have the children.
Not to my knowledge.
4/26, your parenting time day,
Correct.
you worked from 9 to 4,
Yes,
Chris did not have the children.
correct. To my knowledge.
4/28, your parenting time day,
Correct.
worked from 9 to 4,
Correct.
Chris did not have the children.
Not to my knowledge.
5/5, you worked from 9:30 to 4,
Yes,
your parenting time day,
yes,
Chris did not have the children.
correct. Not to my knowledge.
5/16, your parenting time day,
Yes,
you worked 9 to 1 and 2 to 4,
yes,
and Chris did not have the children.
correct. Not to my knowledge.
So it's a little small. 5/19, was that your parenting time day?
Yes,
And you worked from 9 to 2,
yes,
and Chris did not have the children during your parenting time, correct?
well, I was out of work before my children got out of school and I picked my children up from school that day. So Not sure why that's up there.
You picked them up from school on 5/19.
Yes, I did.
Did you tell Chris that you were going to be working and that he could pick them up from school that day?
I do not know.
I'm sorry, what?
I don't know, but I know that I left work at 2 o'clock so that I could go pick my children up. 2:30 when Maddie gets out and 3:40 when Daniel gets out.
Oh. Ms. Tabaka, at the last show cause hearing we had on the work parenting time provision, do you recall testifying about your belief that when Mr. Tabaka would ask you to let him know when you would be working or let you know via our family wizard that he wanted to exercise parenting time during your work, that he was harassing you?
I don't remember specific communications.
You don't remember specific communications, or you don't remember testifying that you believed that he was harassing you?
Honestly, I don't remember a lot from that long ago, but generally speaking, I wouldn't be surprised if I said that he was harassing me because he's done it to me for over 10 years.
So when I'm talking about harassment in this context, I'm talking about the specific allegation that when he asks you about the work parenting time provision, you respond that he harasses you, or you opine later that he's harassing you. Do you agree with that?
I can't agree with that.
In fact, you've put it in pleadings that he harasses you by asking about work parenting time provisions, correct?
I don't know.
All right, I'm going to show you a pleading dated, one that you signed on 7/27/2022, and it's entitled Plaintiff's Answer to Defendant's Motion for Order to Show Cause and Request for Makeup Parenting Time. All right, let me just show you the start of that. So this is when you were represented by Mr. Schaefer, Alexis, and then I'll just skip down to this. That's your signature?
It is.
All right, and with respect to the work parenting time provision, your answer to number 6, you're talking about the work schedules, and that you say defendant has gotten to a point of harassment and making demands that are detrimental to the well-being of the minor children, correct?
That is what it says there, yes.
And I would just note for the record, Your Honor, in the show cause hearing transcript from May 12, 2023, there's a long discussion with Ms. Tabaka about Chris's request for the work parenting time provision to be exercised, characterized by Alexis as harassing from pages 12 to about 15. Ms. Tabaka, the days that the children have piano, there's no court order, is there, that there's no court order that the work parenting time provision is not exercisable when the children have piano and you are at work, correct? So in other words, let me state it a different way. If you're working and the children have piano, the work parenting time provision is still in effect, correct?
I really have no way of answering that because that order was written during preschool and daycare years where piano and extracurricular activities weren't even a part of the children's life at that time.
Right, but we went through a lengthy proceeding and the court gave an interpretation of that order. And in that interpretation, Mr. Tabaka is entitled to have the children after school if you work, no matter what their activities are. Would you agree with that?
I would absolutely agree that Judge Kirkham did say that moving forward from the hearing on May 12th, that Chris would be able to facilitate those activities instead of my mother if I was working.
Well, as a matter of fact, the court interpretation of that was retroactive and he awarded Chris parenting time for the times that he had been deprived after school, correct?
No, Attorney Elaine, I do not believe that the judge awarded him any of those times that my mother was handling piano, that was meant as May 12th forward. And from May 12th forward, that has been not violated at all.
So your testimony is that from May 12th forward, well, you quit work right after that hearing, right? You quit.
No, I never quit my job.
You went out on leave, correct?
I was on personal leave, correct?
You were on acclaimed medical leave, correct?
Correct.
All right, and you applied for that leave or inquired about that leave right after the hearing where Judge Kirkham held you in contempt of court, found you violated the work parenting time provision, and said it was still in place moving forward, correct?
My inquiries for personal leave, actually with the department, long pre-existed that. That's just the culmination of when it ended up going into effect.
Well, that's not true either, is it, Ms. Tabaka? I'm going to show
No,
you.
it is true. I'm sorry, Attorney Lane. It is true.
I'm going to show you what we've marked as Exhibit G. Oh, and by the way, Your Honor, I would move to admit the time cards, Exhibit B.
Ms. Tabaka, any response to the offer of those time cards?
I don't know what that means, Your Honor.
Well, I'm inquiring whether you have an objection to the admission of those exhibits.
Does that just mean that they go into evidence?
Yes.
Oh, that's fine.
Okay, the court will admit defendant's Exhibit B.
Who's Brandy Aldrich?
Randy Aldrich is Human Resources at the county.
The county where you were previously employed?
Where I am employed, yes.
You are no longer employed by the Calhoun County Sheriff's Office, is that accurate?
I am still employed by Calhoun County.
You have a job position open to you if you come back, but you are not working for the sheriff's office, correct?
There is no job position open to me at this time.
Okay.
However, I am still employed by the county in good standing.
Okay, so you're employed by the county, but you have a different job than you did when you worked for the sheriff's office as a bookkeeper. You're not a bookkeeper for the sheriff's office, correct?
Presently, correct.
And you don't work for the sheriff's office, correct?
I do not have a job position at this time with the sheriff's department.
Okay, all right. And this email from Brandy Aldrich to you is dated May 16th, 2023, which was a Tuesday, correct?
Correct.
And this person, this Miss Aldrich, is transmitting to you FMLA and short-term disability paperwork. So I assume you requested paperwork to be transmitted to you if she's transmitting it, correct?
Yes, this is the second time that she sent me this paperwork.
Just please answer yes or no to the question. And we had our final hearing in the first show cause on May 12th, 2023, where you were held in contempt of court, correct?
Correct.
And in fact, you did apply for Family Medical Leave Act, correct?
I did.
And then in your, I believe it was your deposition in August 2023, do you recall that I asked you to waive your HIPAA rights and provide a release so that I could receive your medical records?
I do.
And do you recall that at a later date, you did in fact sign a release and transmit it to me, waiving your HIPAA rights?
I do recall. Mm-hmm.
And then do you recall shortly thereafter, and maybe the next day, you withdrew that request?
I did.
And said you no longer agreed to the waiver of your right, correct?
Correct.
Your Honor, at this time, and I guess I'd like to ask you, Your Honor, how you would like to proceed. We dealt with the failure, the refusal to waive the HIPAA release, refusal to, I guess when she withdrew it, she revoked the HIPAA release that she signed. We dealt with this in the front of the court proceeding that is ongoing. I made a motion in limine, so because she has refused to release her rights, which she can do, I made a motion in limine to prevent her and prohibit her from giving any testimony with regard to her physical or mental health, which the referee granted based on the court rule. And I guess I'd like to know if Your Honor wants me to make the same motion in this proceeding, or whether Your Honor would just take the ruling of the referee and apply it.
We could take that ruling because there's no reason for us to again address the same grounds that were in a different proceeding. And that your understanding, Ms. Tabaka, is that the referee did rule that again that you could not offer testimony as to, again, the medical, et cetera, because of your revocation of the HIPAA waiver?
Yes, I do believe so, Your Honor.
Okay, thank you. Go ahead, Ms. Elaine.
All right. You were off work from when to when, based on the FMLA?
Sometime in May until sometime in October.
And then what happened in October with regard to your employment?
Well, I cannot obviously talk about medical stuff. But I was going to return back to work. But my position was no longer available. It had changed hands, and the only position available was not accommodatable to the scheduling conflicts of the continued constant litigation ongoing in my life.
What do you mean by that?
That they couldn't accommodate an employee that had many schedule conflicts, all of these court dates, and appointments, again, at that time with my attorney. It was too conflicting with the needs of the job.
Okay. And when you say you were going to return to work sometime in October, that's because your request for extended FMLA got denied, correct?
I don't know.
You don't know why
I don't recall.
Didn't you apply for additional leave and you were denied?
I don't remember.
Did you work for the sheriff's office in October 2023?
I did.
And do you recall when you worked for the sheriff's office in October 2023?
It was sometime near the end of the month.
I'm going to show you what we marked as exhibit. Actually, before I move on, I would move for the admission of G.
Mr. Baca, do you have any objection to the admission of Exhibit G?
I'm not sure what Exhibit G is.
Exhibit G is the letter from Brandy.
Oh, no, that's fine.
Okay. Defendant's Exhibit G will be admitted.
Thank you. I'm going to show you what we've marked as proposed exhibit J. All right. And Joan Bowers was your boss at the sheriff's office, right?
She was a coworker.
Okay. And she transmitted these hours on your behalf. I assume you didn't fill out a time card for this late October week?
Yes, it was a different position that had different time recording that I was not familiar with.
All right. And when she says you worked 8 regular hours on the 23rd of October and the 25th of October, those would be what hours? Like 8 to 4, 9 to 5?
I don't remember, but it would be somewhere in that normal daytime work range.
Well, what were your hours at the other position?
In my position as bookkeeper?
In the position you were working, you said it was a different position in October or different hour.
Yeah, that was clerk in Marshall, and I think it was 8 to 4.
All right. So what about when you worked 3.5 hours or 3 3/4 hours? Do you remember what your hours actually were?
No, I don't.
So if 10/23 and 10/25 were your parenting time days, then did Chris have the children at any time during those 2 days when you worked a full day?
I don't know. I don't have any recollection of what was going on those particular dates.
And you did not stay at that clerk position past those October dates that we just showed?
Correct.
And I would move for the admission of J, before I forget.
Mr. Baca, any response to the offer of Exhibit J?
No, that's fine, Your Honor.
Okay, court will admit defendant's Exhibit J.
And why didn't you stay at that position?
Because they couldn't accommodate the schedule conflicts in my life because it is a front desk job where somebody has to be there from open to close.
Did you obtain any employment after that clerk job?
I had a casual up to 12-hour a week job that I had applied for during my personal leave time to do something productive and healthy. And that is the job that I'm working in now. It was never really meant to be like my main source of income, but it was a job that I had for work to do and that I've stayed with.
And who is your current employer?
Navigations Inc.
And what are your hours with Navigations Inc.?
Completely variable. Generally, I mean, when I started, I believe it was like 10 to 2, but sometimes it's 9 to 2 or 9 to 2:30 or 9 to 3:30. It just depends on the day. It's grounds work, so it's nothing that requires like set hours and set things to be accomplished in specific time periods.
Well, it sounds like the hours generally, and I understand you say they are variable, but generally they're during the normal workday, even though somewhat shortened, correct?
Yeah, they're during like daylight hours.
So how is it that that job can accommodate your busy court schedule when you're required to work from 10 to 2 or 9 to 2 or 9 to 2:30 and so forth?
Because it was a 12-hour a week job where those hours could be put in basically any time during the week.
Okay. So your testimony is if you have court, for example, you can just shift your hours to a different day that week.
Correct.
And who selected the 10 to 2 or 9 to 2 or 9 to 2:30? Who selects the hours that you have to appear for?
My supervisor, Dennis, communicates with me weekly to see what's in my calendar so that we can, plan for the following week's work schedule.
And did you inform your supervisor that you did not want to work any morning hours before, let's say, 9 o'clock?
No, it's all variable.
No, did you inform your supervisor that you did not want to work before 9 o'clock in the
I'm
morning?
not sure that I ever specifically said that, no.
Did you inform your supervisor that you had to be done with work by a certain time in the afternoon?
I let my supervisor know what days of the week are my parenting days and that I pick my children up at these specific times and they're accommodating to that.
All right, so you've made sure that your work hours are such that you do not have to offer Chris any work parenting time, correct? Any parenting time during your work hours?
Sorry. I make sure my work hours are such that I can have my parenting time with my children.
All right, and then Your Honor, I think I understood correctly at the beginning, but correct me if I'm wrong. We're just going to deal with this show cause, get this one done, and then move on to the other one. So I would not ask Ms. Tabak anything about the other one at this point in time.
That's fine.
Okay. All right. I don't have any further questions for her at the moment.
Okay. Mr. Baca, do you wish to provide any testimony concerning this first show cause filed by defendant?
Yes, Your Honor.
Okay, go ahead.
All right. In the exhibits that I turned in to the courts, I believe it's my first, possibly second exhibit. I don't see my list in front of me. But it's the spreadsheet that looks like this that was provided to me by Attorney Elaine with the dates and the hours.
You have, the first thing, you have a bunch of stuff written on it and you have it marked as, I guess, Exhibit 1. Is that correct?
It should be, I apologize. I had my list in front of me.
Your Honor, I would object to the omission of this exhibit. First of all, a lot of it is illegible. I'm unable to read it. Second of all, it seems testimonial in nature. She's just taken our exhibit and scribbled all over it. There's things crossed out, which is confusing. There's things that are darkened that I can't see. It's not it's prepared obviously for the litigation. It's confusing. I think it's more confusing than helpful for sure, especially in the fact that I can't read parts of it.
Well, I guess she'll have to testify as to those particular parts, but it is your exhibit that she's responding to, so.
I mean, it's even cut off over on the side. There's writing on the left-hand side that I can't even see parts of the handwriting.
Again, she can testify to that if she wants.
Okay.
Go ahead, Mr. Baca.
Thank you, Your Honor. So yes, this is a spreadsheet that I received from you. These notes are for me to explain everything that we just covered a moment ago, but on 11/9/22, the amount of time that you have listed that you are trying to make up for that date is 1 hour. Are these questions I should be asking you or Chris? I really don't know.
No, you're not asking any questions at this point.
Oh.
You're testifying.
Oh, I'm just fine. Sorry. Thank you, Your Honor. You have it listed that you're claiming, Chris is claiming 1 hour. The second date, 11/15/22, the claim is for 1 hour. I'm going to go back up to the very first one and just do these individually. So he's claiming 1 hour of parenting time. And my mother picked the children up for me. Maddie got out of school at 10:50 and Daniel got out of school at 11:50. And it takes my mother a little over a half an hour's time to get back home from Marshall. And so I was home with my children the same time my mother arrived home from picking them up for me. Tuesday, 11/15/22, they're claiming 1 hour of parenting time. The day I worked 8 to 4. The children had piano lessons that day at 3, 3:30, and 4, meaning the last piano ended at 4:30. So I got out of work at 4. Their piano ended at 4:30. I was home with my kids by the time my mom got home from facilitating those piano lessons. On Friday, the 18th of 2022, a day that they're claiming 3.5 hours. This was a snow day where the schools were shut down. And I had no notice from Chris regarding anything pertaining to that day, if he wanted to get the kids or any offer to travel to get the kids in the weather. And so that's what that is. Wednesday, November 23rd, 2022, they're claiming 6 hours of makeup parenting time. This was a date that I had planned several weeks in advance with Aunt Debbie and Aunt Denise. That they were setting up a play date with some of their kids and my kids. And this play date, this was, again, before the ruling that you made on May 12th regarding me working and not being able to plan anything for my kids during my parenting time. So I couldn't retroactively go back and change that, but I did offer those 6 hours to Chris back in August when they first brought this issue up. Tuesday, 11/29/22, They are claiming 2 hours. And this again was a piano day where the children don't conclude their piano lessons until 4:30 p.m. I worked till 5 and mom got home around 5. So again, we were home at about the same time. Sometimes my mom stops and gets dinner for the kids just to have grandparent time with the kids too. But Friday, December 12th, 2022, they're claiming 1 hour. And let's see, my mother picked the kids up for me. Daniel doesn't get out of school until 3:40. I was out of work at 4, so I was home to receive the kids before my mother even got home with the kids. Let's see, 12/7/2022. They're claiming 2 hours. And this was a day that my mom picked the children up from school and wanted to take them out to dinner. So I just worked until my mom let me know they were on their way home from dinner. Tuesday, 12/13/22, they're claiming 2 hours. This again was a normal piano Tuesday where the last piano lesson concludes at 4:30. And it takes my mom at least half an hour to get home. I ended work at 5, so we were home together about the same time. Friday, 12/16/22, they're claiming 1 hour. I worked till 3:30 that day. My daughter was at school until 5 p.m. because she had a school dance. And my son doesn't get out of school until 3:40. So I wasn't working really at all during a time that would be where there'd be parenting time to Chris there. Wednesday, 12/21/22, they're claiming 2 hours. On this day, Maddie and Daniel, they had math Olympiad and piano lessons after school. So I remained at work longer while they had their extracurricular activities, which their father actually participated in. And I was home when my children got home from those activities. Tuesday, 1/10/23, they're asking for 3 hours. All of the children had piano, which again concludes at 4:30. On this particular day, my mom wanted to take them to dinner, which she informed me, and so I just remained at work until they were done with dinner, and then I met them at home afterwards. On Friday, January 27, 23, they're claiming a half an hour's time. I worked until 3:30 that day. Maddie gets out at 2:30. Daniel gets out at 3:40. So I'll just leave that. They're asking for a half an hour of time. It takes longer than that just to get to Marshall. Wednesday, February 1st, 2023, they're asking for 1.5 hours. I worked till 4:30. Maddie and Daniel, looks like Maddie had piano at 3:30, and then Daniel was picked up, I'm picking up Maddie at 4. They had piano until like 4 p.m. on that day. And again, it takes my mom at least 30 minutes to get home. I worked till 4:30. We were home about the same time. Friday, 2/3/23, they're claiming 30 minutes of time. I got out at 3:30, which is before Daniel even gets out of school, and that's an amount of time that takes longer just to drive to Marshall and back. Wednesday, 2/15/23, they're claiming 1.5 hours. Says they work till 4:30. My mom picked the children up. Daniel gets out at 3:40. And so I left work like about the same time that they were coming home or getting home. Friday, 2/24/23, they're claiming 4 hours. This is the second date in their list where there was a bad snowstorm and all the schools were closed. And it was a Friday, which means that if Chris had even asked for the children, I would have had to travel on those dangerous roads to Marshall with the children and back, and then to Marshall and back, 2 round trips because it was my Friday, my weekend, and the children were already with me. On Wednesday, 3/1/23, they're claiming 1.5 hours. My mom picked up the kids, Daniel, who gets out the latest, at 3:40, and I was home at approximately the same time that they arrived home with my mother that day. Wednesday, 3:15, they're claiming 1.5 hours. Again, same scenario. My mother picked the children up from school for me, Daniel getting out at 3:40. And then me getting home at the same time that they would get home with my mother. There was the Monday 4:10 that they have on this list, which of course I expressed in communication in August that Mondays aren't my days, and I don't know why it's on my list. Then Wednesday 4/12/23, they're asking for 1.5 hours. Same scenario as above. My mother's picking up the children for me. And then I leave work at approximately the amount of time it would take for her to get home and me to get home at the same time. On Tuesday, 4/18/23, they're claiming 2 hours. This was a day that all the children had piano lessons, which end at 4:30. And again, it takes my mother at least 30 minutes to get home after piano lessons. And I would have arrived home before or at the same time she was getting back with the kids. Friday, 4/21/23, they're claiming 1 hour. I worked till 4. My mom picked my son up. Daniel gets out last at 3:40. And so I was home before they got home from school pickup. Wednesday, 4/26/23, they're claiming 1 hour. Same scenario. I worked till 4. Daniel didn't get out of school till 3:40. So I was home before my mother got home with the kids. I don't know if I just said this one. 4/28. There's a bunch they have in April. 4/28, same scenario, claiming 1 hour. I got out at 4. Daniel was picked up by 3:40, and I was home before they got home with my mom. 5/5/23, they're claiming 1 hour. They got out at 4 p.m. So same scenario. My mom picks them up. I'm home before they even get home from pickup. Tuesday, 5/16/23, they're claiming 1 hour. And again, I was out by 4 and I was home before the children got home with my mother. And I do believe they added a date after that. Yeah, 5/19, which, as I said before, I got out of work at 2 and I picked my kids up that day. So I'm not sure why that one is even on there. So that's my analysis and what I have gathered from once I was able to actually sit down and review this spreadsheet that was provided by Attorney Elaine and go through the dates and correspond them to OFW communications and the children's calendar of events, I could break it down and see where all this time was. Most of these dates are on piano days where the children were in Marshall much later than normal. And my mother would facilitate the piano lessons because she's also a pianist. And I would always work it out so that I would be at home by the time my kids got home with my mom from those lessons. I tried to resolve a lot of all this entire motion for these hours with Attorney Elaine and Chris back in August. I had put together, and this is in my exhibit, and I'd like to read it if I may. It's an email that I wrote called Answer to Parenting Time.
Objection to hearsay.
I
wrote
her
it.
words, Miss Elaine. How is it hearsay?
Because it has to be offered against herself. If it's a party, the only way it can come in is if it's a party admission she's offering it against herself.
She can answer. I mean, she's giving testimony. She can give testimony as to what happened on these particular dates. So
Right, but at this point, it's a settlement negotiation. The whole email chain is labeled not admissible through MRE 408.
Mr. Baca, you can't testify as to settlement negotiations. You can
Your Honor,
testify.
this
You
is
can testify if you offered makeup parenting time, but you can't testify as to the negotiations.
Yes, sir. This was not an email pertaining to negotiations. This was an email of me breaking down everything that I just read in that spreadsheet. So, I mean, I could have written this again on a piece of paper to read to you today, but I figured I would just read it because I had it clearly written out in an email that I composed myself, not to Attorney Elaine.
Okay, go ahead.
Your Honor, though, still, she can testify, but it's not proper for her to read something into the record.
Well, Ms. Tabaki, you can testify about this, but you can't have documents that you're reading from that are not, again, exhibits or not in evidence, etc. So testify to what you want to testify to.
All right. When I reviewed the entire spreadsheet day by day and compared it with all of the calendars and took into account the outcome, of course, of the May 12th hearing that we had where you made rulings and decisions on the denied parenting time, on what the provision meant, on the specific hours that you did award Chris, on the hours that you did not award Chris, and on things that would not be considered, such as short periods of time that would be consumed by travel, and the where you ruled that Chris could be allowed to facilitate the activities after school moving forward. I considered that because they're disregarding that ruling and using it retroactively. You didn't award those times where my mother helped me with the kids, but you did say that moving forward she couldn't do that. And despite them knowing that, they still included that in this motion against me, and they still included, I mean, most all of the dates that they provided to you 31 and a half of those claims are for periods of time that are 2 hours or less. And also, their tally of hours for all of the denied parenting time they're claiming in total did not add up to the 53 and a half that she claimed in her opening. I had to count it over and over to make sure I was correct, but there was actually only 48 hours in that spreadsheet that she gave me. So, and again, they threw in Mondays, which aren't my days at all. And I don't know if that was just to add hours to make it look like there was more time that I was denying that was actually factual. The total amount of makeup time in their list for periods of time over 2 hours came to 16 and a half hours of time. And 7 and a half of those hours, Your Honor, were on those adverse weather days where the schools were closed. Chris didn't request to get the kids. He didn't request to drive on the bad roads to come and pick up the children. And they were already with me and would have been with me for the weekend. So that would have been 2 round trips on those dangerous roads, transporting the children. So, I mean, if you want to count those hours at 16 and a half, if we don't count those hours, it would have been less than 10 hours of makeup parenting time. And I believe specifically based off of your review of all the hours from the original hearing, Your Honor, I did remember that you did grant him parenting time for the days where I had prearranged family engagements, like with the grandparents or with the aunts. And so one of those days, the 6-hour day on November 23rd, where I had made plans with the children's Aunt Debbie and Aunt Denise to have a play date, I immediately offered up that time to the defendant back in August, of which, of course, that was refused. There was no interest to resolve. So I believe that I put forth very valid effort in trying to resolve this. And I did it based off of how you ruled on the hearing on May 12th. I remembered you said no periods of time that would be eaten up by transportation, short periods of time. And again, the piano and my mom was May 12th moving forward, and that's over half of what they have here. So this, Your Honor, is why I do consider it to be harassment, because I shared all of these facts with the defendant and his counsel for every single one of these dates. I said, but, you know, Judge Kirkham ruled no short periods of time, and that seems to be ignored. I mentioned, you know, that the piano and my mother helping out was moving forward, and that didn't matter. That seems to be ignored as well. And again, I did offer time, and it didn't matter. There's no desire to resolve the issue, because I think there's more of a desire to just keep me in court. So
Anything else, ma'am?
no, sir, that's all.
Okay. Ms. Elaine, any recross?
Yes, just a few. Ms. Tabaka, since you and Chris communicate through Our Family Wizard only, can you show us where you offered him the time on November 23rd, 2022?
No, because that was before the judge ruled that I needed to do that. Everything was May
I
12th forward.
Okay, I understand that piece, but you testified just a few moments ago that you immediately offered Chris the time on 11/23/2022. You said from the original hearing, the judge granted Chris parenting time, but you had play dates lined up, and you had a play date lined up on 11/23/22, so you immediately offered Chris that time in August of 2022.
Yes, ma'am, I did, but you requested to Judge Kirkham that
No, I'm just
this
asking where
this not
where
be supplied. This is the email to you.
No, I'm asking you where you offer that up. That's so if it's the email, that's the answer, but that's what I'm trying to find out. Where did you
Yeah,
offer?
yeah, on August 30th, 2023, when I had counsel, my counsel provided all of that information that I just shared with the court in an email to you in an effort to resolve
All right.
the
So you
matter.
said 2022 a few minutes ago. So you're talking about August
Sorry,
30th, 2023.
2023, August
And
30th.
you're saying that Mr. Schaefer wrote an email to me, right?
Correct, because at that time I had counsel.
I know, just so you're not saying that you told Chris that he could have the time because this happened afterward. I'm trying to get clear because I wasn't clear. So you already had deprived him of the time on November 23rd, 2022, and then you're saying you acknowledged that at some point later, correct?
I'm saying that I had used my parenting time to facilitate a play date with the children's family that I did not know was later in May going to be considered something that I could not do. Because
Okay.
as far as I had known since the inception of the order, my parenting time is my parenting time. And if I want to use it for family building and the children getting to see their family, that's normal,
Okay. Yep.
common practice.
All right. I understand now. I thought you were trying to say that you had offered Chris the time on 11/23 and he had refused it, but I understand the timeline now. Can you point out to us where in Judge Kirkham's order he said anything about 2 hours or less?
I don't have that order in front of me. I'd recall him saying short periods of time, and especially those that would be eaten up by transportation, the time lost in transportation.
Okay. Let's take a look at the order so we know exactly what it says. All right. This is, I believe, the order after the first show cause hearing. The clarifications and interpretations that Judge Kirkham provided to us. Can you show me there where it says anything about time eaten up by transportation?
I see the provision does not apply to periods of 1 hour or less. I didn't write these orders, so I don't know why the transportation part isn't in there. It would be in the transcript.
Okay, so you don't see it in this order, correct?
No, I don't see it in what you have in front of me.
So when you testified a few moments ago that some of Chris's claims are for 2 hours or less, you would agree that you don't have a basis for ruling out any of his claims that are an hour or more, right? So if you deprived him of 2 hours, he's entitled to those 2 hours back or 1.5 hours.
No, Miss Elaine, on those dates where he's claiming those 2 hours or 3 hours, those were dates where my mother was facilitating the piano lessons and then occasionally would take the children to dinner after piano lessons. And so those are periods of more than an hour, but those weren't included by Judge Kirkham in May, but they were to be moving forward.
Can you show me in the order that Judge Kirkham issued where it says that your mom can pick up the children from school?
I don't have this document in front of me. All I have is the part where you're showing me, but I can tell you I do remember clearly because I found it to be rather disheartening when when Judge Kirkham said that my mother couldn't help with my kids' after school activities. So
I think he said she couldn't help with them. I think what he said was when you are working pursuant to the 2015 order, that is Chris's parenting time. He didn't say your mother couldn't help out in other ways, but where in this order does it say that you're entitled to deprive Chris of time while you're working after school if the kids have lessons or if your mom wants to spend time with them?
I don't know where it would be in this order, but I do recall from the hearing on May 12th that the judge didn't retroactively give Chris the time that my mom had helped me with piano lessons, but moving forward, Chris was granted the right to be the person that can facilitate those activities after school. And if I'm working, and that has not been violated since the judge made that ruling.
Well, where in the order does it say, I'm going to put it back up. Where in the order does it say that future forward, Chris could have the after school time?
Attorney Lane, I don't know where it would say in that. This is what was said in the hearing.
Do you understand, and you may not as a layperson, but do you understand that a court speaks through its written orders? So that only what can be enforced is in a written order, not something that was said in court?
No, I don't know apparently a lot about the legal process, and I'm reading this right now, or I'm trying to process reading this right now. Give me a minute. See, to me, I don't understand why it wouldn't be in there.
Okay, but you agree it's not? And I can show you, I mean, the rest of it is just, the first part of it is how he's going to make up the time, paragraphs 1 through 6. And then these were some explanatory notes that the court gave, and your counsel prepared this, correct? Mr. Schaefer prepared this order. You see that?
I can see that, but I don't understand. I guess, see, because I don't understand how the legal process works. If it was your motion, why he would have prepared the order.
Okay. Let me just double check my notes here. I might be. All right, I am finished with my questions for Ms. Tabaka.
Okay. Ms.
Oh,
Tabaka, is there anything else that you'd like to testify to?
I guess just the same statements that I had already made that most of what they're requesting are the short periods of time.
Okay, I don't need you to reiterate and
Okay.
state again. So if it's something additional, the court will take it.
No, I can't think of anything on this particular topic, Your Honor.
Okay, thank you. Ms. Elaine, any additional witnesses?
I will call Mr. Tabaka, but may we have about a 10, 15-minute break, Your Honor?
Okay, we'll take a 10-minute recess.
Okay. Thank you.
All right.
With that being said, as always, don't forget to like the video, share the video, and comment your thoughts below. Let's start a dialogue about this topic. As always, subscribe to the channel. See you next time, man. Peace out.